Good afternoon, ladies and gentlemen, and welcome to McGuire-Woods' October Securities Compliance and Disclosure Update. For those of you who are less familiar with the firm, McGuire-Woods is a full-service law firm with more than 1,100 attorneys and 23 worldwide offices. Our securities and corporate finance practice covers all aspects of securities law impacting public and private companies. In just the last 3 years, our corporate finance lawyers have served as counsel in public and private securities offerings having an aggregate market value of approximately $50 billion. The volume and aggregate dollar value of our work in this space repeatedly earns the firm top 20 rankings in multiple categories according to Thomson Reuters and Bloomberg's year-end capital market league tables. Before we begin today's program, I have a few housekeeping items to address. First, I would like to call your attention to the Q&A widget in the lower left-hand corner of your screen. Please utilize this interface to submit questions you may have for our presenters at any time during the program. We will do our best to address your questions in the time allotted, but if we do not get to them, we will follow up with you via email. You'll also find a number of other resources along the bottom of your screen, which you may explore during the presentation. I call your attention to the green meeting materials folder in particular, where you can find a copy of today's presentation slides. Today, our speakers will provide an informative discussion on fairness opinions, solvency opinions, and valuation opinions. The views and opinions expressed in this program are those of the speakers and do not necessarily reflect those of their clients or the firms represented. Without further ado, let me turn it over to Jeff Rothschild, a partner in the firm's New York office, who will introduce today's speakers.
Andrew, thanks very much. So we're really honored here today. On my left is Chris Gregory, a managing director with Duff & Phelps, and on my right is Richard DeRose, a managing director with Houlihan Lokey, widely recognized as two of the most prominent and most frequent providers of solvency opinions, independent fairness opinions, and valuation opinions. I lead the firm's financial advisory practice, and so I represent Houlihan Lokey, Duff & Phelps, and other financial advisors in rendering these opinions frequently. I also do a number of special committee assignments and M&A assignments. And so why don't we take a moment, and Chris, if you want to introduce yourself.
Sure. Thanks, Jeff. Hi, everyone. This is Chris Gregory. I am a managing director in Duff & Phelps Transaction Opinions Practice, which is a group within our corporate finance practice that focuses exclusively on advising corporate boards and GPs of private equity firms across a wide range of transactions and generally delivering fairness and solvency opinions in connection with those transactions.
Great, thank you. And Richard DeRose from Houlihan Lokey is on my right.
I am Richard DeRose. I'm managing director in Houlihan's Transaction Opinion and Board Advisory Services practices. Like Chris, also involved in rendering fairness, solvency opinions, special committee advisory. Been at Houlihan for 15 years, prior to which I was managing director in the M&A and financial restructuring groups at Bear Stearns and practiced M&A law for 5 years at Wachtell Lipton in New York.
A firm I've heard of. Tristan Freeman, one of our corporate associates, is on Richard's right.
My name is Tristan Freeman. I'm based out of McGuire-Woods' New York office. I specialize in mergers and acquisitions, securities law, and financial advisory services.
Great. So again, thank you to both Richard and Chris. It's really great to have you both here with us today. And so with that said, we'll leap right in. I'm going to start on page 3 with a quick overview of financial opinions. There's a table of contents on page 2 for those who are interested in what we'll be discussing today. There are two primary types of transaction opinions. First, a fairness opinion, which talks about the fairness of the consideration changing hands in a transaction, or if it's a stock-for-stock deal, it's the fairness of the exchange ratio in a transaction. And then a solvency opinion, which addresses fraudulent conveyance issues, typically after giving effect to, for example, a proposed leveraged transaction like a dividend recapitalization or a spin-off transaction. Then the other type of opinion out there, is, which frankly I don't get involved in as much, but they are very similar, are valuation opinions, which get rendered to different parties in a whole variety of different contexts. We'll talk just for a slide or two about them towards the end of the presentation, because they're oftentimes outside counsel certainly gets involved less in the valuation opinions, and I see them much less in my practice, but they can still be critically important in a variety of contexts that I list below here: portfolio valuation, financial reporting, ERISA administration, and shareholder agreements. So just to give a highlight here of what we're going to talk about, We're going to focus on the transaction opinions, first fairness opinions, and then we're going to go into valuation concepts behind them, then solvency opinions and recent market trends in each of these things, and we're also going to talk briefly, as I said, about valuation opinions. So we'll move now to page 4, and I'll let Tristan, if you want to address these pages.
Of course. We're going to start our discussion today with a discussion regarding what exactly a fairness opinion is and why a board or a special committee would want one. A fairness opinion is an opinion from a financial advisor as to whether the consideration paid or received in a transaction is fair from a financial point of view to the party who is paying or receiving the consideration. We see fairness opinions used by boards and special committees in order to demonstrate that the board or special committee gathered all reasonably available information in fulfilling its fiduciary duty of care in evaluating and authorizing that transaction. Fairness opinions are not required under either Delaware law or federal securities law. However, most companies will obtain fairness opinions with transactions that require shareholder approval. And it's our experience that many companies will obtain them in connection with transactions of a certain size or significance. For example, a material transaction to the company.
So we'll stop on that point just for a moment. In my experience, they're almost always obtained when you're a public company and you need a shareholder vote, as Tristan just talked about a moment ago. And when a company is doing a buy-side transaction, which will be announced on an 8K, so it's a material transaction, oftentimes the board wants coverage then such that they're going to get an opinion as well if they're doing a material acquisition. So typically, people often ask me, how often do you see them in that context? And the answer is very frequently at this point.
It's useful to know what a fairness opinion is and what a fairness opinion is not. As we know, a fairness opinion is not required by Delaware law or federal securities law. It's also not a substitute for due diligence. It's not a substitute for an evaluation of the other terms of the transaction or a substitute for the good judgment of the board or the special committee. A fairness opinion is a statement that the proposed consideration in the transaction is fair from a financial point of view. It is helpful to a business judgment defense should the transaction ever be challenged. And it can be evidence that a fiduciary has exercised his or her due care.
It's interesting to me that oftentimes when you look, for example, at a public deal, when they list the reasons to do a transaction, they might try and call out the opinion as either the first one or the main one or whatever, and the opinion itself is in a sense a double negative. It's a reason not to not do a deal, but in and of itself, it's not a reason to do a transaction. So in my view, it should never be separately called or singly called out by itself. It should be one of the factors listed, but certainly should not be the only factor listed. We're now up to page 6, so Richard, if you want to give us your thoughts.
Yeah, generally. A fairness opinion can provide important information in a variety of financial transactions. Such opinions validate the price in a transaction from the perspective of only one party generally, and they assess the value of the interest that a party has received as compared to the value of the interest that's given up. And while valuation, and we'll talk about some of the methodology shortly, Chris will, is the key underpinning for a fairness opinion, it's often necessary to consider other factors such as other alternatives that were considered. Was the company shopped or not? In some instances, it becomes a little more qualitative as well. In a sell-side transaction where the opinion is being rendered to the interested party, namely the sell-side shareholders, the operative language is consideration that's received by the shareholders is fair from a financial point of view. And I should point out that term of art, financial point of view, is really meant to denote a range of fair values. It is not a single point, unlike in an appraisal proceeding where it is a dollar and cents determination. This is a range. Sometimes, unfortunately, that range can be quite wide, and to the extent it becomes too wide in subsequent litigation, it can be problematic. In a cash consideration deal, the mechanics are relatively simple. It becomes more complicated where stock of the acquirer is the medium of consideration, requires beyond the three methodologies that Chris will talk about, contribution analyses, understanding the volatility of the acquirer's stock, the float, whether they're controlling shareholders and the like.
And there's also more work that you have to do because then you have to value the acquirer as well.
That's right. That's right. On the acquiring side, it answers the question of are we overpaying for the company? It's the operative language here would be fair to the company from a financial point of view. One of the key issues that arises here is synergies. Oftentimes, or not oftentimes, but sometimes you will find transactions where you're on the cusp. It is fair if you include the synergies, and without the synergies, it may be on the borderline. And so that's an area on the buy side that gets a lot of attention in a buy side fairness opinion. Both of these types of opinions increasingly are being seen in the context of special committees. Ever since the 2013 MFW case, we're seeing more and more special committees being formed, actually in areas where traditionally you might not have seen a committee. If there's any hint of a related party involved, we're seeing those, and especially in the context of MLPs and drop-downs in the oil and gas industry, seeing a lot of that. In terms of repurchases and down-round financings and the like, here it compares the cash received or paid against the range of values for the securities that are either being issued or received. And these opinions can get fairly complex when you have, in fact, a complex capital structure with multiple tiers of preferred and other hybrid securities, especially as you get closer to distressed land. ESOPs don't come up all that often, but those are opinions that run to the trustee on behalf of the trust because that is the principal owner, in fact, the sole owner of the securities. We also see these opinions being requested in the context of indentures that require in a material sale of assets or sale of assets above a certain threshold to a related party that the company obtain a fairness opinion. The issue we find here often is that those indentures aren't really drafted with a good understanding of what's involved in a fairness opinion. So it will require an opinion to a party who's actually not transacting. The company may be selling an asset, but the opinion that's in the indenture will run to shareholders, and it often takes some convoluted language to put those into proper alignment.
It's interesting there. That's one of the few cases I know. Usually an opinion, as we talked about at the beginning, is obtained to help the director show that they exercised proper due care in satisfying their fiduciary duties. In the last example Richard gave, that's really a contractual opinion and not one done to help doing fiduciary duties. Before we leave this page, I was going to note the first three opinions that we talk about here at the top, the first three situations, are change of control situations, which we'd call sort of a standard opinion. And then those at the bottom five or so are really non-standard opinions that typically, for example, the bulge bracket banks won't render, and Houlihan Lokey and Duff & Phelps will frequently render.
Yeah, I think also the point that I think would be true of most firms is the great preponderance of the opinions we render are not opinions as to our own M&A transactions, unlike, again, the larger firms that almost exclusively render opinions with respect to transactions where they are the M&A advisor.
And that's really why I wanted to highlight on this page, which you can see in bold, the special committee or related party or conflict transaction. I'm now going to turn to page 7 when I talk about, perceived investment bank or primary investment bank conflict. So what do I mean here? If you have a large bulge bracket bank who's involved and is helping a corporate either sell itself or sell a division, you really, as counsel for them, you want to make sure you understand that bank's engagements, relationships, and potential conflicts that could come up that would lead or could lead a plaintiff's lawyer, for example, to argue that bank had some other interests at heart rather than its client. In my experience, these typically come up in three different ways. The first one might be called the engagement relationships and whatnot, and that's when the primary bank has been involved and engaged by either the bidder or the other party in the last few years. And then you have to deal, when you're representing the banks, you have to deal with questions about what engagements sort of count in this regard. It's relatively easy to figure out. The investment banking, financial advisory, or lending relationships can be much more difficult, particularly if you're dealing with a large investment bank, figuring out how much revenue, for example, they've derived from their derivatives, wealth management, or foreign exchange transactions, and whether or not you're looking just in the United States, just in North America, or really all around the globe. The second type of engagement, conflict, et cetera, that you need to be aware of is ownership, and that's whether many of these very large investment banks now have private equity arms, for example, so they could own stock in either the target or the bidder. And it's also important that you make sure you understand the deal team's ownership of stock in either your client or the counterparty. Lastly, there was a case a few years back whereby if the investment bank has been pitching for work on the other side, you want to make sure you understand that it's fully disclosed. As they say, sunshine is a great disinfectant. And the goal here, whenever you're talking about and trying to understand an investment bank's potential or perceived conflicts, you want to make sure you have a good understanding of the breadth and depth of those relationships.
Just also point out that in a lot of the instances over the last, call it 5 years, where people have tripped up on any of these, it has real dollar impact. I mean, some of these cases have settled for $70 and $80 million, where in hindsight and litigation, there have been issues involving conflicts of interest that have arisen.
Thank you, Richard. That's certainly true. On page 8, as counsel to these companies, there are a few things you can do to mitigate conflicts. Obviously, the most important thing is to make sure that you ask the bank to disclose their conflicts so that you have a full understanding, again, of the breadth and depth of their relationships here. One thing that you can do is to hire a secondary bank, and certainly Houlihan Lokey and Duff & Phelps are two of the primary investment banks, financial advisors that you'd go to seek such an opinion. And in the event that a go shop is to be run, you might ask that independent bank to run the go shop as well to make sure you have as clean a process as possible. If you are getting a secondary opinion, you certainly want to ask the same conflict questions you asked of the primary bank of the second bank to make sure that they're as independent as possible. And if there is some sort of relationship at play, that you have good disclosure of that, and that there are still good reasons to engage the bank despite that potential conflict. You want to make sure that that bank's fee is certainly not contingent on closing the deal. You might ask the primary bank to provide you with either a full or a partial credit for the second bank's opinion. If you can keep the primary bank's quote-unquote feet to the fire and require that they give an opinion, that's always a good practice. I find that the secondary bank will charge you a lower fee for their opinion if you still have the primary bank involved. And you certainly, in that situation, want to avoid having discussions between your primary bank and the second independent bank. Now I think we'll jump into financial analysis starting on page 9, and Chris, we'll turn it over to you for a while.
And just related to your last comment there, Jeff, we've actually seen engagement structures where we were engaged as either the second opinion provider if there was no conflict. There's 4 parties left in an auction, 2 of them are conflicted, 2 of them are not. And then in the case where a conflicted buyer is chosen, we actually become the independent and only fairness opinion provider. It's just another structure that boards and special committees can contemplate. Moving to page 9, as Richard mentioned, fairness analysis is really focused on what a given constituency is giving up and what it is receiving in return. And in the case of, we'll talk primarily about in the case of the sale of the company, which is probably the most frequent occurrence of our involvement and our delivery of a fairness opinion in an M&A deal. The shareholders are effectively giving up stock or receiving the right to receive some kind of consideration, whether it's cash or cash and stock or all stock, in return for the shares that they hold. And the financial analysis that we use to support the fairness opinion that we're going to give is almost always a valuation analysis. And there's a couple of examples where it's not, but we're going to sort of focus on the valuation analysis that a financial advisor will do to support its finding of fairness. Two of the methodologies, which we collectively call them the market approach, relate to selected public companies and selected transactions. Those analyses rely on what's called the law of one price, which basically says that prices paid by willing buyers and willing sellers for identical assets will be identical. And clearly when we're looking at selected public companies and M&A transactions, we're never finding identical comparables, but we're looking for the closest set of companies or targets in M&A deals that we can use for our analysis. A discounted cash flow analysis is almost always employed as well, and it's one of several types of income approaches that financial advisors will use, and we'll talk about that in more detail shortly. And then in terms of contribution analysis, it's generally seen in merger transactions where the consideration received is stock, and what you're really focused on is whether your ownership, the constituents that you're looking out for, their ownership of the merged company is appropriate given the value of what they've contributed relative to the value of what the counterparty has contributed. Those are generally all what we refer to as our primary analysis. In advising boards and special committees, we'll often include other supplemental analyses, most of which are not demonstrative, but can be certainly helpful from an informational perspective. We'll look at the process, understand the robustness of the auction run, if there was an auction indeed run. In a public company context, understanding the historical stock price can be important, and where the price of the given transaction is relative to that historical trading pattern, and in context with that, whether a premium has been paid in a given M&A transaction. We don't think necessarily that a premium needs to be paid for a transaction to be fair. It's almost always the case that a premium has been paid for a board to want to move forward, but it's something that we'll often look at. In terms of LBO analysis, it's another type of income approach where we'll look at it if we think that the most logical buyers for a given business are financial or private equity in nature, and understand how private equity type returns drive valuation for a given target company.
Yeah, I think though it's important for people to distinguish between approaches that are actually valuation approaches versus other analyses which are absolutely important, absolutely the board should understand, but aren't valuation analysis, because there have been cases like El Paso Pipeline where people got into trouble because they took an accretion dilution analysis and it was masquerading as a valuation, and they got slapped by the court for that. So important stuff, right, but it's different.
Right. Just because the acquisition accounted for using GAAP results in an accretion to earnings does not mean necessarily that the price paid for a given target is fair.
It's a great point, and the way in which we handle that when representing investment banks is to say either A, the other analyses and considerations don't go on the football field. If they do go on the football field, they're sort of under a dotted line which says these analyses are presented for informational purposes only and are not relied upon in reaching our conclusion. And then you put these analyses really in an annex in the back rather than in the heart of the book, and frankly, you're hopeful that you're not describing them in the proxy.
Just in terms of the process that financial advisors undertake, the first good two-thirds of the process is collecting information and doing the financial analysis, which really requires cooperation from the management team, the private equity sponsor, and sometimes in a case of a merger, the acquirer as well, when you need to have information on the merger party to do analysis around the value of that company and its stock in the case of a stock swap. The judgments that financial advisors are applying are really quite wide-ranging. You've probably heard that valuation is really more art than science, and these judgments are really the artwork that financial advisors are producing in their analyses and engagements. Once the analysis has been completed, any fairness opinion is going to go through a committee process that generally involves the risk management committee. In our case, our general counsel and chief risk officer, and a number of other managing directors. And so any opinion that the firm is going to sign has been through that formal fairness opinion committee process.
And I have to say, in my experience at both Bear Stearns and at Houlihan and representing bankers at Wachtell, people sometimes when you say, as you just did, we have a committee, everybody kind of rolls their eyes and thinks it's a rubber stamp. I have seen, several careers ruined by people who showed up at Fairness Committee or Valcom and got it wrong. It is usually a pretty strenuous exercise, and it can be career threatening.
I was a junior banker actually at J.P. Morgan years and years ago, probably almost 20 years ago, and I remember going through the committee process after a double all-nighter was one of the more harrowing experiences in my life.
It can be a blood sport.
Turning to page 10, we'll just talk briefly about the market approach, specifically guideline or selected public companies. And this approach requires that you develop a set of valuation multiples based on the prices at which public companies trade, and then ultimately select multiples for the subject company, your client, based on comparisons of those public companies to the subject company. And one of the first things that you have to do, aside from selecting the group of companies, which we could discuss for an hour in and of itself, the art form of that, is to figure out which multiples you're going to calculate and look at in the context of the valuation. The most common is enterprise value to EBITDA. EBITDA is sort of widely held to be a proxy for cash flow. It's not cash flow, which is important to note, but as a proxy for cash flow, and probably the most common form of enterprise value multiple that is used. But we'll also look at other enterprise value multiples. Enterprise value to EBIT generally captures some of the different levels of capital intensity across both public comps and between the group and the subject company, because it takes into account depreciation. And then enterprise value to revenue you'll often see for companies that are losing money, maybe high growth, life science, software, technology businesses that do trade off of revenue, oftentimes large multiples of revenue. And then for industry-specific multiples, you'll see things like enterprise value to assets under management in the asset manager space, enterprise value to megawatts or sort of power production in the utility and power space. So you need to understand for a given industry what multiples are important. And then in terms of financial institutions, insurance companies, and banks, analysts will often look at equity multiples as opposed to enterprise value multiples. And those will include PE, price to earnings, price to book, and price to tangible book, which is a measure of book value that excludes intangible assets. You also need to figure out what historical and projected time periods you're going to look at those multiples over. Most common would be trailing 12 or latest 12-month multiples, and next 12 months, sort of looking out 12 months from the assignment date, the engagement date. And you need to understand, based on historical cycles, whether there's been a downturn in a given industry, how that's affected multiples. Even in a rising economy like we have today, there are peak multiples right now being paid and certainly being observed in the public markets. That may not necessarily be appropriate for a company that's also achieving peak levels of income currently. And then selecting multiples, also an art form, and what we're looking at primarily is growth, risk, and capital investment. So in terms of how quickly a company's been able to grow, is projected to grow, and whether that growth has been driven organically just by the industry that it's in, sort of rising tide floating all boats, or whether it's grown through acquisition. And then the risk that the company, its business model, that's inherent in its business model, and things like customer concentration, historical earnings volatility are things that we'll look at.
As we skip to the next page, it's a number of the points that Chris has just raised help you focus on why it's so important that you hire a financial advisor who has real industry experience here.
Page 11, just a couple of points on the M&A transaction analysis that we'll often do. We're looking here for multiples that were paid for companies in changes of control, where controlling interests were acquired by a strategic or financial buyer. We're looking for targets that are similar to the subject company, and hopefully the information is publicly available on that transaction. It's oftentimes that it's not publicly available, but as an investment bank, we will have proprietary access to what was paid, multiples that were paid, and we need to be careful about how we use that. It'll often inform our valuation, but not necessarily be disclosed in our board book or in public filings. And then the other key consideration in analyzing M&A transactions is to understand who the buyer was. If it was a large strategic that was expecting material revenue and cost synergies, they'll often pay more than a company would be worth to anyone else. And so you'd want to take that multiple with a grain of salt. Financial buyers can implement operational and capital structure improvements and pay more than public companies trade for, but those are often viewed as being cleaner from a synergy standpoint.
Given the recent decision out of the Court of Chancery, the Enbridge decision, it's also critical if the subject company itself was sold in the last few years, make sure you don't pull an ostrich and ignore that sale. Make sure you understand whatever it was sold at and how that relates to the current sale price as well.
Yeah, that's a good point. I mean, we'll often look back a couple of years to 2 years. If the subject company was sold 5 years prior, we're going to make sure we know what the multiple was on that deal in context for the market at the time. On page 12, we just talk about some of the adjustments that a financial analyst will make in calculating a multiple. The idea here is that you're determining the enterprise value of a company, which is really the clean kind of value of its operations, ongoing operations. You want to make sure that the earnings measure, whether it's EBITDA or EBIT, is also adjusted to exclude any non-recurring items that may oftentimes expenses, but can be things like gains on sale or discontinued ops. So you'll want to make adjustments so that the numerator and denominator of your multiple both reflect the business on a go-forward basis. On page 13, we jump into the income approach here. The income approach basically uses the theory that the value of a company equals the expected return on or expected receipt of future economic benefits that company will produce. In practical terms, we look at cash flows, so we're looking at the present value of different measures of cash flow. The most frequent we would use free cash flow, which is all the cash that's available for the stakeholders of the firm, both equity and debt holders of the firm. And we're going to discount that cash flow using a rate that's commensurate with the risk of those cash flows. In terms of single period versus multi-period valuation models, the single period relatively infrequently used in the context of a corporate valuation. If you have a really stable bellwether company that's operating at steady state and is mature, you can sometimes skip the process of projecting cash flows out 5 or 10 years and just capitalize a single period because it's effectively already at its long-term rate of growth. More often you see multi-period valuation models where you're receiving projections from management, really testing the reasonableness of those, understanding the assumptions that underlie them, and using those to develop the cash flows that you're valuing. At the end of that period, that discrete period that you're looking at, you need to estimate what the firm is worth at that point and into the future. And we'll often look at perpetuity formulas and terminal multiples in evaluating terminal value. On page 14, talk a bit about the forecast that we're using. These are always provided by company management. And sometimes it's necessary to extrapolate if a company's high growth out through its fifth year. We'll often work with management to extend until the company's at a more steady state level of operations. We'll often use equity analysts who may forecast performance for a public client of ours to understand if there's a significant difference between management and equity analyst forecasts. And then the problem of multiple sets of projections, it's not infrequent that we will receive an equity case, which is kind of an upside, optimistic, go-to-market case, and then a bank case, which is probably conservative and not really useful for our purposes. When you're doing evaluation, you really want to be working with the expected case set of projections. And if you don't have that, work with the management team to produce something that is really kind of a 5 on a scale of 1 to 10.
You make the assumption in your engagement letter that the projections that you're getting are really the good stuff, and they're based on the best reasonable judgments of managements, et cetera, and then you'll assume that to be the case in the opinion itself. I'm happy to say the certification by the CFO, where the CFO says, yes, the financial information I gave you was the good stuff. Our financial statements are an accurate reflection of the financial condition of our company, and in solvency opinions, our contingent liabilities are as identified on whatever the schedule is. I'm pleased to say that I really see, I got pushback on that frequently probably 5 years ago, and now I think that's really become a market practice. I think we're up to page 15.
Yeah, in terms of the discount rate, as we talked about, in a perfect world, we're getting expected case projections, calculating expected case cash flows, and then using what I'll call a typically developed discount rate. There are times when you only have what I'll call an equity case where it's aggressive, maybe the case that's going to market, but really everyone would love to achieve those, and they don't necessarily expect to. There are times when you have to either adjust those projections yourself or take into account the extra risk in your discount rate selection. So you may end up using a higher discount rate for a portion of a business that management is expecting to grow from on a greenfield basis, and it becomes half of the business in 10 years. That's obviously riskier than the company's core operations that it's already employing in the market. In terms of risk premiums, we will look at times company-specific risk premiums if there are non-diversifiable risks that exist, things like customer or product concentration. Regulatory risk is another one. We'll try to capture those risks if we can in the cash flows themselves, but sometimes you just can't do that, and you end up having to take into account that investors require additional return when dealing with risks that are sort of outside of their control. Country risk premium, this is just a concept that relates to companies and securities requiring higher return in riskier countries. Developing markets will often need to include country risk premiums. And then early stage companies, this is an area where we've been doing a lot more work in recently, mostly for VCs in connection with cross-fund transactions. But you're looking at companies that are often unprofitable but generating revenue, and you're looking at discount rates that you couldn't develop using what I'll call normal metrics, and really need to understand what those types of investors require. And these rates can be anywhere from 35 to 70% for really early stage kind of pre-institutional rounds, and more in the 25 to 40 range for B round and pre-IPO companies. And really having a pulse on that market is important in being able to determine what discount rate is appropriate. We'll often get involved in distress situations, and there it's a matter of understanding how much additional risk a given situation is required to be incorporated. Sometimes we'll look at multiple scenarios there where the company continues as a going concern. It's worth X, but there's a probability given its current financial state that it's not going to continue and be liquidated, and that scenario will have a certain probability. There are a number of techniques to deal with valuing distressed companies, and it's generally a more challenging valuation than a healthy company.
Chris, only because we're going to skip along a little bit, I think pages 16 and 17 in particular sort of speak to themselves on the page. But if there's anything that you feel we ought to call out, we should do so. I note the first one I find is always the most important on page 16, which is the fact that you get a fairness opinion does not indicate, for example, that that's the only opinion that that's the only price that's fair, or that that's the best price you could possibly get, but rather that the price you're obtaining is within that range of fairness.
I think the only other thing to discuss with respect to synergies and the acquisition premium, in the case of a sale of the company, we're typically looking at the value on a change of control basis, assuming a market participant, which is any hypothetical buyer, not necessarily a specific buyer that can generate synergies, either revenue or cost synergies. So we will take into account in a going private transaction things like optimizing capital structure or removing public company costs, because really any buyer can do that.
Yep.
But generally not other types of synergies, especially on the sell side.
Why don't we skip to page 18, if that's okay?
Sure.
So here, all else things equal, it's obviously best to use all three of the primary valuation metrics, meaning a DCF, a selected public company, and precedent transaction analyses. Certainly if you're not going to be using any of those three primary techniques, whether it's because projections are not are not given to you or not available, so you can't do a DCF, or if there aren't sufficiently comparable companies that you can, public companies that you can find that you think approximate the target company, then you should include a statement in the opinion itself saying, okay, we haven't done whatever the analysis is, and here's why. And also, usually, you don't weight your analyses. Certainly there are cases, if you're only using two of these analyses, for example, where it would be different, but oftentimes you'll have a disclaimer in there saying no particular weight given to any particular analysis. I'm going to move now to page 19 and discuss a few recent trends here. The first one, I probably should have put quotes around public disclosure. Fairness opinions, when given to a public company, are almost all, if there's a stockholder vote, for example, in my experience, are almost always publicly disclosed. But even when you're dealing with private opinions, now folks want it to go out to their LPs and others, and whether or not you can get reliance or non-reliance letters or those folks to sign something saying we agree not to rely upon it are tricky issues that require a lot of conversations. I've seen certainly an increased variety types of transactions, as we talked about earlier in the presentation, related party transactions, fund-to-fund transactions, et cetera, and a lot of requests for non-standard opinions, as Richard alluded to earlier about credit agreements, for example, and then independence has certainly over the last 5 years been a hot topic in fairness opinions.
Just before we leave fairness opinions, I would point out that the Delaware courts, where most of this stuff will, if it does get litigated, will get litigated, that court is very sophisticated as far as courts go in terms of financial analyses. And if you read the cases where valuation has come up, they will really dig into all the methodologies that Chris went through. They will look and examine as to whether your comparable companies, to their satisfaction, really are comparable. Some of the vice chancellors actually have their own DCF models that they run. So it's a sophisticated court. So, as counsel, you need to question and second guess your banker because the court's going to do that. If it comes to that.
I clerked on the Court of Chancery more than 20 years ago, and the court actually has the ability to hire its own financial advisor, which I always thought was interesting.
Yeah, and at least one recent case, they suggested they were going to because of some tax issues that were beyond their ken.
All right, so we're now up to solvency opinions on page 20.
Yeah, solvency opinions generally are less familiar to most people. There is, in contrast to fairness opinions, a dearth of disclosure, thankfully, and we'll talk about that in a bit. They've also been subject to less, criticism, less academic, writings, so they're not generally understood that much. They are opinions that are addressed to or designed to address requirements under both state and federal statutes. They are given in the context of leveraged transactions, whether that's a leverage recap or an extraordinary dividend, or almost invariably in the context of spin-off transactions where there's a sizable distribution. Essentially, the opinion addresses 3 tests that are embedded in the federal and state statutes, and a 4th test that is sometimes delivered in connection with a requirement of Delaware and other state law. The first being that the fair value and present fair saleable value of a company's assets will exceed its stated and identified contingent liabilities. And here I point out that present fair saleable value, it's really a distinction without a difference. It's a legacy of the older Fraudulent Conveyance Act. There is a newer Fraudulent Transfer Act, which has been adopted by, probably something like 46 of the states. I'm not current on the count. So it's something that we have tried to eliminate in our opinions, and oftentimes in the opinion where you're asked to give it because other states may be implicated, the opinion will make the statement that the analysis is the same for both.
It's actually interesting. The fair value is a concept under the DGCL, and present fair saleable value is a concept under New York law.
Right.
Richard's exactly right.
New York is one of the few states that still has, like many statutes, the older statutes. The second test, the cash flow test, assesses whether the company should be able to pay its debts, including identified contingent liabilities, and we'll come back to that as they become absolute and mature. The third test, the reasonable capital test, is that the company that's remaining in the company after the transaction should not be unreasonably small for the business in which the company is engaged or proposes to be engaged. And lastly, there's something called a surplus opinion, which we'll talk about in a few seconds. So why are solvency opinions obtained? Two principal reasons, similar to those for which you would obtain a fairness opinion. First, it provides important information to the board to satisfy its obligation of due care. And importantly, it also provides evidence, ex post facto, that due care was provided. And here, unlike fairness opinions, where if there's going to be litigation, it tends to happen, pretty proximate to the time of the transaction. With solvency opinions, oftentimes the problems that arise several years after the fact. There are also litigations that can drag on for years after the transaction. Frequently what will happen, to the extent the company, heaven forbid, winds up in bankruptcy, to resolve the case, a litigation trust will be formed and funded, and it will pursue causes of action against all kinds of parties for years that can come. And also, solvency is something that can change very quickly, as was dramatically highlighted by Lehman and my former employer, Bear Stearns. It can happen overnight. Unsecured creditors have a panoply of causes of action that can be pursued, and as I just mentioned, they can be pursued years after the fact. The law is not all that well resolved around some of these issues, especially when a company is operating in the so-called zone of insolvency, where creditors have the ability to bring derivative actions. Important in that context to have a solvency opinion. And importantly for the board, because it is like a fairness opinion protection, there is an analog in the DGCL Section 172 that provides the same protection as 141 does for the fairness opinion. It fully protects the board in relying on outside experts as to the existence of surplus in an opinion. Reasons why opinions are being obtained, because some of the consequences can be sort of catastrophic, including unwinding of the transaction itself. We have seen, directors, it's one of the few areas under 174 of the statute where directors can actually face personal liability, personal monetary liability for the willful or negligent declaration of an unlawful dividend. Secured creditors may lose their credit standing, may lose their security. They may need to settle for a substantial discount to that which they thought they were going to receive. Selling shareholders, amazingly, can face having to readmit to the company the proceeds they got in the transaction. Now, this was not so much of an issue for a number of years because after the financial crisis, Section 546E of the Bankruptcy Code was put in that in insulated transactions that went through a financial intermediary, as most merger transactions will, proceeds are distributed through a bank or another distributing agent, and those were deemed to have the benefit of this 546E. Well, last February there was a Supreme Court case called Merit Management that said that only is in effect where that financial institution is in fact the beneficiary. To the extent it flows through to shareholders, it is no longer protection. So people in going forward may well try to unwind transactions and recoup from public and other shareholders. And lastly, advisors. There is an analog to aiding and abetting fiduciary duty. There is an analog in terms of aiding and abetting a fraudulent conveyance. I was involved in the bankruptcy of Interco many years ago in the 80s, and in fact, Wasserstein Perella had to write a $50 million check because it lost an aiding and abetting case in terms of a fraudulent conveyance.
Average. Sounds like real money.
Yeah, even for Bruce it was.
Just one other area where we've seen solvency opinions sought and really driven by the buyer is in the asset sale or divestiture of a company where the selling company is potentially in the zone of insolvency.
Exactly.
The buyer actually wants to have that seller obtain a solvency opinion, and if they can't, obtain a reasonable equivalent value opinion.
Right.
Kristen, you want to skip to page 23?
Yes. It's helpful to understand what a solvency opinion is and what a solvency opinion is not. Similarly to fairness opinions, a solvency opinion is not a reason to do less diligence in connection with a transaction or a type of risk mitigation panacea. As we noted previously, solvency opinions are financial opinions which are provided in an M&A, financing, or spin-off transaction addressing federal fraudulent conveyance statutes and certain state laws, such as Delaware State. They work well as a means to protect transaction stakeholders in case of subsequent litigation, which could result from a financial deterioration of the subject company.
So the elements of the opinion, as I mentioned, the first test, the balance sheet test. This is not an accounting exercise. It really doesn't rely on the book value of the company. It is an independent de novo evaluation of the company as a going concern. Oftentimes, I find boards are somewhat shocked by the valuation because, quite frankly, a valuation for a solvency opinion is an exercise in conservatism. Sometimes, especially in the context of a spin-off, where the company's other financial advisors are saying that SpinCo and RemainCo are going to, trade at lofty valuations post-transaction. We'll come in with a valuation that's materially lower. It's intended. There's no one's benefit that's served by an aggressive valuation. I would just point out most of the things here Chris has already talked about, but a key thing is at the bottom, identified contingent liabilities are included. They're an important aspect of the analysis. Frequently, we will have to work with other outside experts to the extent those liabilities are beyond our ability to value them, be those asbestos, silicosis, environmental, some litigation claims, things like that. We work with counsel and outside experts to come to an informed basis for our valuation.
The interesting thing here is the underlying valuation of the company is based on the exact same metrics that we talked about before for fairness opinions.
Exactly. Second test, the cash flow test, is really two parts. The first is an examination of historical trends, the business that's being operated, the business conditions, the industry, and making sure that there is a certain consistency between the current projections and past operating performance and the reasonableness of the projections in terms of what we understand the future of the industry and the company will be going forward. Once satisfied with the reasonableness of the projections, the second test is the sensitivity of those projections and the sensitivity of key variables in those projections to certain exogenous influences, basically saying, okay, here's what we think the world will be, but what will happen to these projections, what will happen to our margin of error if it turns out contrary to our expectations that the world turns out differently. So we will come up with a case, we'll work with management to see what keeps them up at night and develop a case that alters certain key variables and come up with downside cases and rerun those projections to make sure that the company is able to satisfy its debts and operate the business of the company with a margin of error to it.
This is one of those rare places where fairness and solvency differs a little bit. On the fairness side, the financial advisor always says, okay, I accept the projections as you give them to me. I'm not reaching an independent conclusion. Here, on the other hand, the base case you're really accepting, but then it's your responsibility as a financial advisor to run some sensitivity and to to really test the assumptions underlying those projections.
That's right. The last test, the reasonable capital test, is probably the most qualitative of the three tests. It relies certainly in large measure on the results of the balance sheet and the cash flow test, and it's designed to assess the amount of equity left in the capital structure after giving effect to whatever transaction it is you're assessing, the so-called equity cushion. We compare that to the equity cushion in other similar companies, but then we go on to examine certain factors that insulate a company from unexpected downturns, be that market share, barriers to entry, the term structure of the company's debt, the magnitude and timing of the contingent liabilities I talked on, quality of management, various qualitative things like that also go into the analysis. Now, as I mentioned, there's a fourth test. It's a test that's under Delaware Section 170 and similar statutes in other states. It really comes into play where there is a dividend or a distribution. Sometimes this is a test that will be asked to opine to in isolation. They will not ask for the full solvency, but if they're showing negative shareholders' equity on the balance sheet, a company may well want a capital surplus opinion before declaring a dividend.
And we've even seen that just for regular dividends, not non-special.
Yeah. Yep. Some of the trends we see here, public disclosure. As I mentioned, you don't typically see these publicly disclosed. There is a good reason for that because it is a slippery slope. We've seen situations that we've had to negotiate with the SEC on disclosure. In the fairness opinion context, there is disclosure of a lot of information, a lot of detailed financial analysis. You really want to avoid that, and your client really wants to avoid that in the solvency context because, as I just mentioned, we have these downside scenarios. We're looking at contingent liabilities that may not sometimes be publicly disclosed. There's a lot of information in there that you and the client really don't want to have out in the public domain. This particularly comes up in the context of reverse Morris Trust transactions, where oftentimes a solvency opinion is a condition to the merger, and we've had a couple of situations where it really took a lot of negotiation with the commission to avoid disclosure. So the issue here is also if there is early disclosure in a draft S1 or Form 10 that's confidentially filed with the commission that references, with a blank or parentheses, a specific provider of an opinion, it then goes on to, well, who were they? Okay, can we see their analysis? Oh, you really should disclose it. So that's become a big issue.
You always want to change that if you can to a
nationally recognized. And you want to wait, if ideally possible, and this is the no red flags at the bottom, to deliver your opinion at the time that the dividend or the distribution or the spinoff or whatever it is approved, not at some earlier point in time. Sometimes there is a lag between some board action and implementation. Will oftentimes give the board, quote, no red flags comfort that we'll be able to deliver the opinion, and this way we sort of avoid some of the disclosure issues. Insolvency opinions have come up, not too often, most notably in Huntsman Hexion, Bell Canada, and Dow Rome Haas, where people were trying to get out of a transaction and were claiming that the transaction resulted in the subject company becoming insolvent. There aren't too many of those out there. Retrospective analyses really are for dispute resolution ex post facto when one of those parties I alluded to earlier is suing on a fraudulent conveyance. Oftentimes need a retrospective solvency analysis.
And I do find that the no red flags analysis is sufficient for your directors when they're reaching the determination to make a dividend, does give them the protection they need under the duty of care.
Yes.
I know that we're scheduled to wrap up at 1:30, which I think is now. I've been told we can continue on for just 3 or 4 minutes. We're really towards the end of the presentation now. We're at the last 2 pages discussing valuation opinions, so certainly if you have to run, feel free to do so. And if you can stick around with us for the next 3 or 4 minutes and are interested in valuation opinions, please do. Chris, you want to take 20 minutes?
So valuation opinions are used for a wide variety of purposes. A couple of big buckets would be financial reporting, so valuations used in the context of preparing companies' GAAP or IFRS compliant financial statements, tax-related valuations, and that can be shareholder level or corporate tax, and then what I'll categorize as board advisory valuations. And those can be used in the context of redemption offers that a company is making, maybe it's a private company, tender offers, to help adjudicate shareholder agreements, buy-sell agreements, where an independent investment bank or valuation advisor is required to deliver an opinion of value. And the analyses that we use in the context of valuation opinions are always appropriate for their purpose. So it could be different if it's tax-related versus financial reporting versus a board advisory valuation, including the 3 methodologies that we talked about earlier.
And lastly, we'll finish up with portfolio valuation. This, over the last, I want to say, 3 or 4 years, has become a very significant portion of certainly our practice, and I believe Chris's firm's practice as well. Valuations provided to private equity and hedge funds with respect to their portfolio holdings. It's been motivated by 2 predominant factors: increased activism by limited partners, and maybe even more importantly, the attention of the SEC. A number of actions brought in the last year or 2 with respect to private equity firms where they have found that there was a mismarking of positions. That can oftentimes be a function of the fund's desire to enhance its management fees or to help itself in marketing, and the SEC really has latched onto this issue. So more and more general partners are seeking fairness opinions or portfolio valuations to buttress their valuations in terms of fairness, in terms of a transaction, be it a recap or a fund-to-fund transfer, or just an evaluation in terms of their valuation marks in the ordinary course.
The other thing to add just on portfolio valuation, the secondary market for limited partnership interests has really ballooned in the last couple of years. And so you have these limited partnership interests trading, and they generally trade as a percentage of NAV. It can be at a discount or at a premium. So there are sort of market-based determinations out there in transactions. And so it's that much more important that between the purchase of a portfolio company and the exit, that the GP gets those valuations correct in that during the hold period.
Great, thank you. So with that said, I think we're at our conclusion. I like to leave time for questions. I'm afraid we didn't have time to do so. Our contact details are on the pages at the back, with the exception of Richard. I'm afraid I inadvertently left them off. His email address is rderose@hl.com, and I'm sure he'd be pleased to take your questions and either answer them or forward them to me to be answered. Andrew, with that, so I definitely wanted to thank Chris and Richard again, and Houlihan and Duff for letting you both come over and giving us your thoughts today. Very much appreciated. Andrew, with that said, I'll turn it back to you.
Great. Well, thank you again to our guest speakers, Chris and Richard, and to Jeff Rothschild and Tristan Freeman, McGuire-Woods attorneys, for a great program. And thank you, all of you, for joining us today. We hope you enjoyed the program. As Jeff noted, if we did not address your question during the time allotted, one of our presenters today will follow up shortly with an email. If you were unable to access the presentation materials for whatever reason at the start of the event, you can refresh your browser and the materials should be available in the meeting materials folder. In addition, in the next few days, presentation materials and the full audio recording for today's program will be made available on the McGuire-Woods website. Again, thank you all for participating in today's SEC Compliance and Disclosure Update. We look forward to seeing you at our November presentation on hot topics for the 2019 proxy and annual reporting season, currently scheduled for Tuesday, November 27th. On behalf of all of our presenters and McGuire-Woods, thank you for joining us today.